Hello everyone, welcome to the Arbitration Channel. My name is Lauro Parenti. On August 25 and 26, we had a great pleasure to organizing the Arbitration 2 Worlds event. It was the first joint venture between Columbia Law School and the New York University School of Law, the NIU. The event was held in New York at JAM's office and the Brazilian Chamber of Commerce. The event was coordinated by Professor Carlos Alberto Carmona, Ricardo Figueira Torre, Gustavo Fávero Vang, Rafael Alves e Caetano Berenelgar. We also thank all supporters of this initiative: Sérgio Bermudes Advogados, Cleary Gottlieb, Marques Rosado Toledo César e Carmona Advogados e Valde Advogados. The event featured two keynote speakers, Professor Franco Ferrari and Professor George Bermann. We had put together these two presentations in this video so that all those who were unable to attend the event had the opportunity to watch the presentations. We also thank you all the other speakers had been there, presential, and we hope see you in 2023 in New York. We will start with the Professor Franco Ferrari presentation and after the Professor George Bermann presentation. Thank you all.
Good morning or good afternoon. Today, I will show that the suggestion that international arbitration is free from the restraints of national law, as submitted by some commentators, is not tenable. Actually, the contrary holds true. I will show that arbitration remains embedded in various national legal systems, to use the words of one commentator. This, however, means to use an oft-quoted statement by F.A. Mann that, and here I'm quoting, in the legal sense, no international commercial arbitration exists. Every arbitration is national arbitration, that is to say, subject to a specific system of national law, unquote. Including, of course, the law of the seat, but, and this is where my view differs from that of F.A. Mann, not only the law of the seat. I will also show that despite attempts by some commentators to somehow free the international arbitral process from domination by the law of the place of arbitration, the law of the seat retains its prominent position among the various national laws that may apply in relation to a given arbitration, as if the lex arbitri were a prima inter pares. Now, the seat, in my opinion, still anchors the arbitration to the national legal order of the state in which the arbitration takes place. This in itself should, in my opinion, be enough to make my point that international arbitration is national arbitration. Also, some colleagues want to convince us of the contrary. One cannot today deny that the arbitration regimes of most countries declare, by way of conflict rule, that they apply whenever the place of arbitration is located in that specific country. Now, this holds true for basically all 111 model law jurisdictions. And of course, this is unsurprising. The model law being clearly based on the territoriality principle as per its Article 1.2, pursuant to which, and here again I'm quoting, the provisions of the arbitration law of a specific state apply as a rule only if the place of arbitration is in the territory, shopping for a lex arbiter. We know that by fixing the seat of the arbitration in the country whose law retains the seat as a criterion of application, the parties are certain to trigger the application of that law. This is relevant because despite the apparent convergence of arbitration statutes in different developed jurisdictions, and the imposition of international standards under, for example, to give just one example, the New York Convention, highlighted by some commentators, differences between the various arbitration laws of individual states remain and in some instances are substantial. And it is these differences that allow places of arbitration to compete fiercely to attract arbitration to their respective territories, in which states have created so-called arbitration havens to attract transnational business. Now, the territoriality principle certainly helps states to do so. Why? Because it creates certainty as to which lex arbitrary will be applicable ultimately. And it is against this positivist understanding of the law and the territorial sovereignty of states, as some colleagues say, that both the delocalization debate, which has been current since the 1950s, as well as a push towards autonomous arbitration and, so to speak, an autonomous arbitral legal order, have to be viewed today. Now, these two movements share a common goal, namely to limit state interference in international arbitration. Where the autonomy advocates differ, however, from their predecessors, the delocalizationists, is in the scope of their ambitions. The aim of delocalization was simply to sever the tie between the national law of the seat and the conduct of the arbitration and, of course, enforcement of the law. In other words, this latter movement merely, so to speak, aimed and still aims at demystifying the seat by enabling the arbitral process to be independent of the national legal system at the seat of arbitration, while the former movement, the one towards the autonomous legal order, is aiming much higher, as hinted earlier, at an arbitral legal order existing somehow independently of state and international legal orders, as one colleague puts it. But neither the autonomists nor the delocalizationists have reached their ultimate goal. And today, the law of the seat of arbitration continues to be of paramount importance, despite what some colleagues want to tell us. I'm not suggesting that one should subscribe to what has been labeled the so-called monolocal theory, understood as a theory advocating that the law of the seat operates as the exclusive, as the sole source of the arbitral process. This is not what I'm advocating. I suggest that it is still the law of the seat that primarily furnishes arbitration its regulatory norms in the form of ground rules in accordance with which arbitral activity may validly take place at the arbitral seat, as one colleague says. It is not, however, the only law imposing itself upon international arbitration. In other words, the regulatory sovereignty of the state of the seat of arbitration is not necessarily the only one to be triggered during the different stages of an arbitration's life cycle. Now, this is due to the fact that this regulatory sovereignty encounters both subject matter limitations and, of course, territorial limitations. Accordingly, depending on what matter is to be addressed and when and by whom, of course, the regulatory sovereignty of states other than that of the seat may be called into play. Now, from what I've said, it follows that all matters that may arise in the context of an arbitration are subject to a specific system of national law, understood as an expression of the regulatory sovereignty of a state mentioned earlier, including, of course, the decision to enter into force international conventions, such as the New York Convention, which I will be speaking about later. Therefore, it is national law that the juridicity of arbitration is rooted in, meaning, to use late Emmanuel Gaillard's words, where the source of the arbitrator's power and the legal nature of the process and of the ensuing decision stems from. As stated by Rusty Park, national law gives arbitration its legally binding character. This does not mean, again, that all matters are necessarily subject to one single national law, such as that of the seat. Multiple laws may be and generally are applicable to one and the same arbitration. the specific national law applicable to a given matter will depend, of course, on the context in which the matter is addressed and, once again, when and by whom. But it will be a national law, including the international conventions that have become part, of course, of that law. And as mentioned earlier, national laws differ from one another. This is important because informed parties will be able to take advantage of these differences over the course of an arbitration, including, of course, when determining the seat of the arbitration, where to seat the arbitration. In fact, by choosing to seat an arbitration in a jurisdiction, the arbitration regime of which relies on the seat as connecting factors, the parties make applicable the law of the state in which, of course, the arbitration is seated, thus generally elevating the law of the seat to the lex arbitri, of course, with all of its idiosyncrasies. According to one commentator, this promotes certainty without sacrificing party autonomy. On the one hand, because it is the parties who may choose the seat of the arbitration. And on the other hand, because most of the provisions of national arbitration laws are non-mandatory in nature. As his colleague states, there is very little true use cogents within these arbitration laws, as most of the rules are of default nature only. Now, this is due to the delocalization movement and that aiming at an autonomous arbitral legal order mentioned earlier, having influenced national arbitration regimes. And this is actually why these doctrines, these principles have to actually be praised for what they have allowed national arbitration law to become. In fact, to the extent to which party autonomy has any effects, however, remains an issue to be measured against the national arbitration law applicable to the specific issue in relation to which the autonomy is asserted. There is no party autonomy without a legal order granting it. This should be very clear. And in those states in which the arbitration regime relies on the seat as connecting factor, that legal order is, at least a priori, that of the seat. In these states, it is this legal order that provides at the outset the lex arbitri, the body of rules which sets a standard external to the arbitration agreement and the wishes of the parties for the conduct of the arbitration. It is this law, with all of its idiosyncrasies, that sets outer limits to party autonomy in relation to the many issues it addresses, which at the pre-award stage include, to list just a few, the determination of when an arbitration is international and triggers certain more flexible rules vis-a-vis rules on domestic arbitrations that normally are less flexible. The validity of the arbitration agreement, the capacity to conclude arbitration agreements, subject matter arbitrability, the composition of the arbitral tribunal, of course, the existence and the extent of the arbitral tribunal's jurisdiction to decide on its own jurisdiction, the extent of judicial supervision of or interference and assistance in the arbitration proceedings by courts, whether arbitral tribunals are entitled to grant interim measures, which in some countries they are not, whether it is possible to hold hearings and deliberations in a place and state other than that of the seat, and so forth. The lex arbitri is also relevant, of course, at the post-award stage. Most importantly, because it determines the law applicable to the grounds for setting aside the award and the courts that have the exclusive authority to set aside the arbitral award. Now, one may submit that there are instances where a foreign annulment regime extends its reach beyond the foreign territory in which it is enforced, of course, on the basis of a criterion, other than the seat, other than that of the seat, and this necessarily so. But even in this exceptional type of situations, where the foreign annulment regime may come into play, the courts of the seat will retain annulment jurisdiction, just not an exclusive one in this limited type of circumstance. And these courts will resort to their domestic annulment rules, certainly where no foreign lex arbitri was chosen, a choice that anyway is rather rare. And these rules, these domestic rules, may well differ from state to state. This means, for instance, that it is the lex loci arbitri that will determine not only the grounds for annulment, the time limit within which the application for set aside will need to be filed, the specific court that is actually competent to hear such annulment application, and whether a decision by that court can be appealed or not, which is not possible in all jurisdictions, as we know, but also whether the parties may or may not agree to limit or expand these grounds. A few words on this issue. Some jurisdictions recognize self-imposed limitations on the scope of review at the post-award stage. Under French law, to give just one example, parties may at any time expressly declare a full waiver of the right to initiate set-aside proceedings as per Article 1522(1) of the French Code of Civil Procedure. There are other jurisdictions which allow for the possibility to fully waive the right to initiate set-aside proceedings. Of course, the conditions, the requirements according to which waivers of the right to seek a set-aside are possible and enforceable, and the effects thereof vary unsurprisingly, of course, across jurisdictions. Also, some jurisdictions reject the possibility of a full advanced waiver of recourse against an arbitral award. Unsurprisingly, between these two extreme approaches, one finds various intermediary positions. Some jurisdictions, for example, allow parties to waive certain grounds for set-aside, but not those aimed at protecting the public at large. Other jurisdictions only allow waivers from parties that have no link with the place of arbitration at all. According to yet another approach, waivers are only allowed to be declared a posteriori and not in advance prior to rendering the award. Many differences can be discerned also in respect, of course, of the answer to the question of whether the parties are allowed to restrict rather than fully waive the grounds of review. As regards the expansion of the scope of review at the post-award stage, of course, similar differences can be observed. But there is one element all of these approaches have in common. They all, without exception, rely on the lex loci arbitri as the starting point of their evaluation as to the admissibility of a partial or full waiver and an expansion, thus showing, in my opinion, once again, how important the choice of the seat is. The seat is also of utmost importance in relation to recognition and enforcement proceedings, at least in those 170 states today in which the New York Convention is in force. Why? This is actually due to the very location of the seat of the arbitration determining whether the application of the New York Convention is at all triggered in the recognition and enforcement forum. In effect, under the New York Convention, the only decisive factor for its application is whether the award was made in the territory of another state. Thus, the convention does not apply if the award does not have a foreign nationality, so to speak, unless, of course, the award is not considered a domestic award in that state. And whether this is actually the case will depend on the location of the seat of arbitration, in the sense of legal or juridical home or domicile of the arbitration. Furthermore, the seat also determines whether the award was made in a state that allows the recognition and enforcement states formal reciprocity requirement, where it exists at all, to be met. In relation to the United States, to just give one example, it is para 1.3 of the restatement of the US law of international commercial and investor state arbitration, which in my opinion makes this very clear. Of course, one could say that in light of the vast number of contracting states to the New York Convention, the importance of this reciprocity requirement is continuously decreasing. That may well be true. But this does not mean that the overall importance of the seat for the purposes of the New York Convention is diminishing with the increasing number of contracting states. The seat determines and will continue to determine whether the arbitration took place under Article 5.1d and where the award was made pursuant to, for example, Article 5.1a, providing for non-recognition and non-enforcement of an award made under an arbitration agreement, which is not valid under the law to which the parties have subjected it, or failing any indications thereon under the law of the country where the award was made. To give another example, Article 5.1e, as we know, provides that recognition and enforcement of an award may be refused if the award has not yet become binding on the parties or has been set aside or suspended by a competent authority of the country in which or under the law of which, again, that award was made. This, in my opinion, clearly confirms the preeminent role of the seat also for recognition and enforcement proceedings. More so, considering, as I said before, that parties rarely choose a lex arbitri leading to an arbitral procedure law other than that of the seat, as also confirmed actually by very recent case law. But while the courts of most states acknowledge the seat importance also in this context, and under what is probably still the prevailing position, an award that has been set aside in the country of origin is no longer capable of enforcement in another state, at least as a matter of principle. The courts of a small group of countries do not. This holds true most notably, although I have to say not exclusively as we know today in France. Having espoused the view that international commercial arbitration, the arbitral procedure and any resulting award should be autonomous, therefore unconnected not only to the law of the seat and its courts, but to any law, as if it were autonomous, French courts give effect to arbitral awards when enforcement is sought in France without actually concerning themselves with the views of the courts of the seat. And they do so relying on the one hand on Article VII of the New York Convention, which recognizes, as we know, the right of the party obtaining the award to benefit from the more generous approach of the domestic law of the state of enforcement. On the other hand, they rely on French national recognition and enforcement regime being more generous than that of the New York Convention. Why? Because it does not, the French national law provides that annulment of an arbitral award by the court of the country of its origin is a ground for refusing its recognition or enforcement. But this recognition and enforcement regime is a domestic one. This has to be understood. And it is as a domestic one, as a domestic regime, as the reaction of a single national legal order among the multiplicity of orders which may have the occasion to play a role in the life of an arbitration, that this regime is applied through Article VII of the New York Convention. It is not, and I want to be very clear about this, an emanation of a freestanding discretion under Article 5(1)(e), which may actually well not exist, and allows French courts to disregard set-aside decisions by the courts of a primary jurisdiction. In other words, the rule at hand is part of French law rather than part of a phantomatic autonomous arbitral legal order, and consequently applicable in France only. This, however, is, in my opinion, but a further confirmation of the importance played by national arbitration laws and their many, many differences. This in turn means that international commercial arbitration is not international commercial arbitration. The differences in the national arbitration regimes in which international commercial arbitration is necessarily, in my opinion, embedded, do not allow one to speak of a uniform concept of international commercial arbitration subject to a uniform regime. Absolutely not. Although, of course, there are very many common traits in each international commercial arbitration. It is therefore correct to state, as one German commentator has just done in the Handbook of International Arbitration, Mr. Balthasar, that, and here I'm quoting from his text, such labels do not do justice to the complexities of arbitration law and convey an impression of uniformity that does not correspond to reality. In effect, arbitration law and practice remain far from being fully harmonized. Attempts to unify arbitration law have remained unsuccessful, and as a result, legislation, case law, and legal practice in the field of arbitration continue to differ from jurisdiction to jurisdiction. Even where harmonized laws and principles apply, solutions adopted by local courts do diverge. Accordingly, awareness of differences in legal cultures remain key in international arbitration, and of course, there is a need for caution to avoid unjustified comparisons and uncritical importations of private foreign theories and, of course, usage. Thank you very much for listening to me today.
So bear with me. I'm in Paris and not suffering too much on that account. So as some of you may know, one of my concerns recently about international arbitration has been the concept of what is pro-arbitration or arbitration friendly and what isn't. I want to explore with you a recent case that some of you will know that will illustrate how misguided it is to think that some things are pro-arbitration when they're not pro-arbitration. And that causes me to want to ask myself and to ask you what you actually think pro-arbitration means. Now, as background, I'm going to take a case with which many of you are familiar and not deal with it just as background. Of course, I'm referring to the case, the decision of the United States Supreme Court, in which the court held that it was fundamental that parties have a right of access to a court to determine whether a tribunal has jurisdiction or not. That is not the view in every country, but in the United States, it's firmly established that a party resisting arbitration has a right, if it wishes, to a judicial determination of whether that party consented or didn't consent to arbitrate. And the Supreme Court, as many of you know, has said that that right is so important that it cannot be lost in the absence of clear and unmistakable evidence that you relinquished your right to a judicial determination. Now, many of you know that in the past, the most important cases have been those that raised the question of whether, if you have a competence clause in the rules of arbitration that you adopted, or in the arbitration law under which you are arbitrating, that the presence of that clause means that you no longer want a judicial determination, an independent judicial determination of whether you consented to arbitrate. Now, I'm not here today to discuss those cases with you because we all are familiar with them. It's an old story. For those of you who don't have background, let's simply say that the prevailing view in the US is that while you have the right to an independent judicial determination of whether you consented to arbitrate, you lose that right if there is a competence clause in your rules or in the lex arbitri. Now, I'm not here today to discuss those cases with you. That's simply background. But we now have, as some of you know, a much more serious example of what I consider to be a mistake in calling something pro-arbitration when it is not. And it builds upon the cases I just discussed with you. So the case I'm thinking of was decided by the Second Circuit Court of Appeals last year. Any students in the room from Columbia will have heard of this case, but it is getting a great deal of attention and widely regarded as deeply flawed and an example of what may be thought of as pro-arbitration is not pro-arbitration. So let me talk about this case with you and then raise a few general questions. So the case I'm thinking of, decided last year by the Second Circuit, is an investor state case, an investment by Chinese investors in Mongolia. The case name is Beijing Shougang v. Mongolia. This was an expropriation claim brought by the Chinese claimants. And when that claim was brought, Mongolia challenged the jurisdiction of the tribunal. It's not for me to decide whether its challenge was justified or not. All we need to know is that Mongolia said the tribunal lacks jurisdiction. And the tribunal, in fact, declined jurisdiction. The Chinese claimants sought annulment of that award, which dismissed their claim. I'll stop here to say we usually think, I do, of parties seeking annulment of awards rendered holding them liable. Many of our cases are cases in which a party held liable seeks to set aside the award. This is one of those somewhat less common cases when it's the claimant that was disfavored, the claim was dismissed, and the claimant wants the dismissal, the award dismissing its claim, to be set aside. And the claimant asks the court to exercise independent review over the jurisdictional question, over whether there was consent to arbitrate. And the respondent said, oh, no, you don't have a right to a judicial determination of whether you consented to arbitrate. And the reason you don't have that right is because you argued in front of the tribunal in favor of jurisdiction. Now, let me stop there for a moment, just to be sure you understand that what the district court said, because it agreed with the respondent, was that because the Chinese claimants appeared before the tribunal to defeat a challenge to arbitration, it clearly and unmistakably gave up its right to have the award rendered against it reviewed independently by a court. Put differently, when the claimants, faced with a challenge to jurisdiction, agreed that the claim could be bifurcated and the jurisdictional question submitted to the tribunal, that doing that was clear and unmistakable evidence that the claimants did not want judicial review of whether or not they consented. So I want to ask you, please, to put yourself in the position of a claimant faced with a challenge to jurisdiction, and what should that claimant do? What should a claimant do when the respondent challenges jurisdiction of the tribunal? I think most of you would agree that what a claimant will do is respond to the challenge. The claimant will respond to the challenge and seek to demonstrate that the tribunal does have jurisdiction over the case. But that is exactly what the claimants did here. And because the claimants appeared and affirmed the jurisdiction of the tribunal, the court said, well, now you cannot get a court to review the question of whether you consented to arbitrate. Now, I ask you, I've asked myself, I've asked my students, what should a claimant do under those circumstances other than what I just described? You're a claimant, there's a challenge to jurisdiction. What are your options? I said a moment ago that you would be most likely to appear before the tribunal and defend the jurisdiction of the tribunal. If you don't do that, if you don't seek to defeat the jurisdictional challenge, then, well, your case is over. And that raises the question of whether you think a claimant faced with a challenge to the jurisdiction of the tribunal should have to go to court for a judicial ruling. And if it doesn't do that, then it has no post-award judicial review. I'm curious, I hope we have a chance for discussion, but I'm curious about what others would think about requiring the claimant, in my case, having brought the arbitration, faced with a challenge, now being told, well, you'd better go to court if you want judicial determination. Otherwise, you stay in the arbitration and you have no post-award review. Now, we know from a famous prior case, known as first options, that the court disagreed with that. And the court said a party that does not have to bring a lawsuit in order to establish jurisdiction, and it doesn't have to bring a lawsuit in order to defeat jurisdiction. The jurisdictional question may be left for the arbitrators. And when an award is rendered, the jurisdiction of the tribunal may be questioned, post-award review. And if we go back to first options, in that case, it was the respondents who were challenging jurisdiction, not in our case, the claimants asserting jurisdiction. But what the Supreme Court said in first options is that the respondents are free to defeat or try to defeat a jurisdictional challenge. And if they lose, that does not mean that they lose their right to a judicial determination after the award is rendered. And then I would ask you, if the respondents who are challenging jurisdiction are allowed to have de novo review after the award is rendered, why shouldn't a claimant whose claim is dismissed have full judicial review of the existence of jurisdiction? But what's important is to recognize that the Supreme Court held in that case that merely arguing jurisdiction to a tribunal does not lessen your right to a post-award review of whether there was jurisdiction in the first place, again, unless you clearly and unmistakably indicate otherwise. So this decision may be regarded as pro-arbitration. Why? Well, it's a decision that basically promotes arbitration by telling parties either you argue jurisdiction before the tribunal, or you get de novo review after the award is rendered, but you can't have both. I'd like you to think about, what is your supposition? What is your supposition? Do you suppose that if a party argues jurisdiction before a tribunal, it has no right to post-award review of jurisdiction? I can tell you that no one has ever thought that in the United States. No one has ever thought that you have to choose between discussing jurisdiction before the arbitrators and getting judicial review after the award is rendered. No one has ever thought it contradictory or inconsistent to argue jurisdiction to the tribunal, and if you lose, be able to challenge the award on jurisdictional grounds. And that is what we've learned in the Second Circuit case, is the state of the law in the Second Circuit. So, practically speaking, all that a respondent has to do is challenge jurisdiction. That's all it needs to do. And if the respondent challenges jurisdiction and the claimant responds, the claimant loses its right post-award to a judicial determination of whether it agreed to arbitrate. Now, I will say it's possible, but we don't know, that the claimants in this case failed to preserve their jurisdictional objection. Recall, the case was dismissed on the basis of a jurisdictional objection by the respondent. Perhaps the claimants did not formally register their objection, did not preserve their objection, but the case doesn't tell us that. So I want to come back to this idea of what is pro-arbitration. The Second Circuit, in this case, unquestionably thought that the judgment it rendered was pro-arbitration. You can tell that from reading the judgment. So in effect, this court thinks it is pro-arbitration to deny you review of the jurisdiction of the tribunal in a court because at the beginning of the arbitration, you argued jurisdiction to the tribunal. You made that choice. It's one or the other. Now, I'm quite sure, and I know the judge who rendered the judgment, I'm quite sure the court thought it was rendering a very pro-arbitration judgment. It allows this dismissal of the claimant's claim to avoid judicial review, so the award survives, even though the only mistake the claimants made was to defend the jurisdiction of the tribunal at the outset. And so the question for me, is it really pro-arbitration for this to be the policy of the court? Is it pro-arbitration merely because the award is affirmed, regardless of the circumstances? And as you may gather from what I've said, I think it isn't pro-arbitration to deprive parties of the right to question whether there was jurisdiction over them. We're not talking about review of the merits. We're talking about review of consent to arbitrate. Now, I've been thinking about this problem of what is pro-arbitration and what isn't for some time, but I've thought of a good many examples of where I think we've mistakenly called things pro-arbitration that really aren't pro-arbitration. And we have to ask ourselves, what are the criteria for deciding whether something is pro-arbitration or not? So, good example. As some of you may know, many decades ago, the prevailing US view was that if you went to a court for interim relief, you waived your right to arbitrate. If you went to a court for interim relief, that was inconsistent with your intention to arbitrate. And that was called, that decision, those decisions, were called pro-arbitration. It was thought it was pro-arbitration to ensure that courts can't interfere with the arbitration by entertaining requests for interim relief. That was the pro-arbitration view back then. I doubt there are too many people in the room who think it is anti-arbitration for parties to be able to get judicial interim relief. in aid of arbitration. And so today, we call pro-arbitration, access to a court for interim relief. What we call pro-arbitration was held to be anti-arbitration some years back. I want to give you another example. This one comes out of my own experience, and it's a difficult situation. Let me explain. We have a case in which the validity of a patent is called into question. Okay? We have a patent infringement case, and the respondent calls into question the validity of the patent. And we're before an arbitral tribunal in which I'm sitting, and the question arises, well, that patent, the very same patent at issue in that case, is now in the Patent Office of the United States, which is going to rule on the validity of the patent. This is a very interesting scenario, I think you'll agree. We have an arbitration, patent infringement, where the validity of the patent is a critical issue, but at the very time that that arbitral tribunal is sitting and meant to decide that question, there is a proceeding in the Patent Office concerning the validity of the patent. Question, is it pro-arbitration to go ahead and decide the case, the validity of the patent, and not wait for the Patent Office? Or is it more pro-arbitration to show deference to the Patent Office and allow the Patent Office to make its determination of the validity of the patent? Bear in mind, if the Patent Office upholds the validity of the patent, there's still things for the tribunal to decide. Notably, was there infringement? But the question of the patent's validity came up in my case, and the tribunal was divided on whether it should go ahead and determine the validity of the patent, because that was an issue in the case, or whether it should instead suspend proceedings and allow the Patent Office to make its determination. And once that determination is made, the arbitration continues. And if the patent is valid, the tribunal decides whether or not there was infringement. This was a really good example of where a tribunal had to did discuss, and had to decide what was the pro-arbitration thing to do. I'd be very curious to know what this group thinks. It may come as no surprise to you that I think, contrary to what you may think, that the more pro-arbitration thing to do is to show respect for the Patent Office. That's one view, and it was my view. But my two co-arbitrators thought that the only pro-arbitration thing to do was to proceed with the arbitration and disregard the fact that the validity of the patent is at that very moment before the Patent Office for determination of its validity. I said a moment ago that whether something is pro-arbitration or not should depend on the criteria you want to use. You need criteria to decide what's pro-arbitration and what isn't pro-arbitration. And I'm of the view, and it is somewhat heretical, that it isn't always pro-arbitration for an arbitration to proceed. And it isn't always pro-arbitration to shelter an award from review over the question of whether a party consented to arbitrate, which was my Second Circuit case. If you measure pro-arbitration by how many arbitrations we will have, and how many awards we will have, and how regularly the courts uphold those awards, then you will come to one set of conclusions. But if you're someone like me who thinks that we shouldn't measure what is pro-arbitration by what will give us the most arbitrations and the most awards and the greatest likelihood that awards will survive challenge, it's pro-arbitration for arbitration to be legitimate. I take a long view of what is pro-arbitration. And a last final example I'd like to give you is really the question of consumer arbitration. And I think this is a good example of where one might say it's pro-arbitration to subject consumer disputes to arbitration. It's pro-arbitration because we extend the field of arbitration. And we have a larger number of arbitrations, a greater number of awards, and arbitration is favored. But I think I would not be the only one who would say it is more pro-arbitration not to allow consumer arbitration, which is, of course, the policy in many countries in the world. I think that's a good example of where we have now come, I think many of us have, to the conclusion that arbitration is better off. Arbitration is on a sounder footing if we do not arbitrate consumer cases than if we did arbitrate consumer cases. Now, I've given you a lot of different cases to think about. I started with the Second Circuit decision, which I said was viewed by the Second Circuit as pro-arbitration. But is it pro-arbitration for parties to be denied access to a court to demonstrate that there was no consent to arbitrate merely because that party discussed jurisdiction before the tribunal? Is that pro-arbitration? I think you know. I think it isn't. The patent case. Is it the question? Is the question of whether the pro-arbitration move is to go ahead and hear the case, or is the pro-arbitration move to suspend proceedings and allow the patent office to make its determination? Well, many would say, I would not, that it's pro-arbitration for the simple reason that the arbitration keeps going. And if the arbitration keeps going and is allowed to keep going, then that's pro-arbitration, irrespective of the price that may cause. Now, is there a price? I think there's a price. When the patent office is deprived of the opportunity to exercise its own jurisdiction by a tribunal that believes that it should show no deference. The arbitration should go on and no deference should be shown to the patent office. I gave you the example of consumer arbitration, where we can also discuss the question of what's pro-arbitration and what isn't. You know, my view is it's pro-arbitration to not have consumer arbitration. And my last example that I gave you was interim relief from a court. Interim relief from a court. And then you want to ask, well, what are my criteria there? And my criteria there would be, to what extent is allowing a court to grant interim relief during an arbitration, to what extent is allowing a court to do that harmful to the process and cause prejudice or injury to anybody? And I think most of us would agree that one is fairly clear. That at the end of the day, there's more to be gained by allowing courts to grant interim relief when justified than categorically prohibiting courts from doing so because their doing so looks anti-arbitration. I believe that the case I gave you in the Second Circuit, I believe that that is one of the largest, one of the greatest pro-arbitration missteps that we've seen in a very long time. And most of the arbitration community happens to agree with me. Unfortunately, the Supreme Court denied certiorari in this case earlier this year, but a very dangerous and superficially pro-arbitration decision remains on the books. As we go forward in our careers, and my career is academic and arbitrator, I think it a good idea, and I try to live by that idea, that I try critically to think when the time comes to make a decision, like whether or not to defer to the patent office, whether that is the pro-arbitration thing to do. In conclusion, all I want to suggest is that rather than use the label pro-arbitration on the basis of appearances, we should attach the label pro-arbitration only after we have determined that it is in the long-term legitimacy interest of arbitration to make the move we're about to make. Many can disagree over all the examples I've given you, and I'm sure there are people in the room who do disagree over the examples I've given you. But I hope none of you will disagree with the proposition that we should think really deeply and carefully before we come to the conclusion that a policy or a decision is pro-arbitration and should be taken for that reason. I think acquiring the habit of thinking critically about what's pro-arbitration is pro-arbitration. That's my message for today. I think it's important from time to time to step back and look at what we're doing, step out of the weeds, and asking ourselves, what are we doing and why are we doing this? I want to leave my comments there. I don't know whether Q&A is anticipated or comments are anticipated. But that is what I had wanted to say to you today over lunch. Thank you.